This week, on the second day of the new term, the Supreme Court heard oral arguments in Garland versus Vanderstock. That's a case challenging the authority of the Bureau of Alcohol, Tobacco, Firearms, and Explosives to regulate ghost guns under the Gun Control Act. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode of We the People, we'll recap the oral arguments, we'll debate whether ghost guns can be regulated as firearms by the ATF, and we'll explore the future of gun regulations at the Supreme Court. And joining me are two leading scholars of gun regulation and the Constitution. Clark Neely is Senior Vice President for Legal Studies at the Cato Institute. Before joining Cato, he was a senior attorney at the Institute for Justice. His most recent book is Terms of Engagement: How Our Courts Should Enforce the Constitution's Promise of Limited Government. Clark, it is always wonderful to welcome you to We the People.
Thanks, Jeff. It's nice to be back.
And Drew Stevenson is a law professor at the South Texas College of Law. He previously served as a legal aid lawyer in Connecticut and became an assistant attorney general for the state of Connecticut. His current research focuses on firearms law and policy, and he's the author of many articles about the Second Amendment. Drew, it is wonderful to welcome you to We the People.
Thank you. I'm really honored to be here.
Let's jump right in with the oral arguments. Clark, this was a statutory case, not a Second Amendment case. Tell us what the leading issues were and how you saw the court responding to them.
Right. So this, as in other cases, this term involves a somewhat esoteric question of not so much whether Congress can do a particular thing, but whether they did a particular thing. A federal agency like ATF only has those powers that are delegated to it by Congress through a statute that Congress passed. So the argument in this case is whether Congress did or did not provide statutory authorization for the ATF to regulate a part of a firearm called the receiver, which we won't get very technical about it, but you just think of it as it's the thing in the middle between the barrel and the stock. Where the action happens, where the round is set off by the firing pin, and you get the explosion that propels the bullet out the end of the firearm. Up until 2022, the ATF had one definition of what constitutes a firearm, and that would be, in effect, a gun that can fire, or could be an object that could be readily converted into a gun that could fire, or the receiver, frame or receiver of that gun. What the ATF did in this rule, and what this case is really about, is that it kind of expanded this definition so that now it's not just a gun that could be readily converted, an inoperable gun that could be readily converted into an operable one, but a not fully finished receiver. A hunk of metal that's been machined in some way so that it's part of the way towards being a receiver, but it's not quite one yet. And this rule that's at issue in this case, we'll call it the final rule, went into effect in April of 2022. It expanded the ATF's understanding of what constitutes a firearm that has to have a serial number on it to include a receiver that isn't quite finished yet and that requires some further some further tooling or machine shopping in order to turn into a receiver that would then actually work in a firearm. And the challengers in this case said, look, that's not the definition that Congress gave, and it's not a permissible definition for the ATF to provide. And so these gun kits that people have been buying that include almost finished but not quite finished receivers should not count as firearms within the definition of that term under the 1968 Gun Control Act. And therefore, the ATF has no authority to require people to put a serial number on any gun that includes one of these you have to finish it at home receivers. I know that's a mouthful, but to sum up, what this case is about is whether Congress actually provided the statutory authority for this new rule that the ATF has been enforcing about unfinished receivers for firearms since 2022.
Great. Thank you so much for that helpful introduction to this technical case. As you just explained to us, Ghost guns are untraceable weapons without serial numbers. They're assembled from components or kits. And you said the relevant debate is over this statute, the Gun Control Act, and its definition of firearms. Section A, as you said, is any weapon which may be readily converted to expel a projectile. And Section B says that the frame or receiver of the weapon is relevant. Drew, how did you hear the justices interpreting both of those provisions? Why don't we begin with this Section A, any weapon, including a starter gun, which is or is designed to or may be readily converted to expel a projectile by the actions of an explosive. How are the justices interpreting that provision?
They are definitely agreeing that there are some incomplete or inoperable guns, let's say a gun that's missing a part or could easily be made functional and operational. And I think that there's no real argument in the case that that those are banned by the statute. I want to, because I teach administrative law, I do want to add a caveat to what Clark Neely just said. There's also no real question, I think, for the justices that the ATF does have some regulatory authority. And so Congress clearly put in the statute that the Attorney General the Attorney General now does it to the ATF, can promulgate some regulations about how the statute should be, what it means and how it should be implemented. And so the problem is when an agency does that interpretation and promulgates sort of fills in the gaps a little bit, is whether they went so far afield from what the statute said that they sort of went out of bounds from the statutory language. And because agencies can't do that, they can't take something that says, okay, you're allowed to define what counts as a firearm and then decide that a tuna fish sandwich counts as a firearm. And I think everyone agrees that both the ATF has authority to make regulations that are compatible with the statute and not authority to make regulations that stray too far afield from the verbiage of the statute. And ultimately, this is a question, most of the discussion at the Supreme Court this week seemed to really focus on how readily convertible these the kits in question are, how long it takes to get one ready to fire, and what tools are actually required, and so forth. So the companies in question are not just shipping a hunk of metal. And at one point, the Solicitor General said she had put together one of these kits herself.
I actually had the experience of putting one of these kits together, and it's just like what the record shows.
And it was as marketed. These kits are marketed as they will only take about 15 minutes and are dummy-proof to put together. If you have a drill and maybe a pair of pliers or a file, things that a lot of people have in their home already, that you can have a gun that's ready to fire. And she conceded at one point that if something took longer than 8 hours, that ATF would probably consider it not to be a firearm under the statute that you just quoted.
Many thanks for that. And for flagging that one question is how long it takes to convert the weapon. Clark, there were a lot of hypotheticals at the oral argument about whether ghost gun parts were more like incomplete omelets or the pieces for a grocery list or IKEA furniture or bicycles without pedals. Tell us about that and how you saw the justices breaking down on the question of whether or not a ghost gun could or couldn't be readily converted into a weapon.
Yeah, it was fascinating. I'm as a lover of colorful analogies, I was particularly entertained by this part of the case. But let's imagine that there's a law that all couches have to have a serial number on them, and there's a debate about what is the thing that you get from IKEA in the box. Is that a couch or is that just the components of a couch? And I think the argument in this case comes down to let's say that provisionally that characterizing a box with a bunch of couch parts in it as a couch and therefore it requires a serial number, is something that Congress could do. But then again, the question in this case is whether Congress actually did that. In normal parlance, we wouldn't call a box with a bunch of couch parts in it a couch, because it's not one yet. It wouldn't be very comfortable to sit on. You wouldn't put it out, for company, et cetera. So that's roughly analogous to the situation with the firearms, because there are people who sell these kits that with enough work, you can turn this kit into a working firearm. And the really key part of that kit, again, is this thing called the receiver, which is where the actual explosion happens that causes the gun to project a bullet out the front of it. And so I think it's really two questions. First, is there enough room in the statute for the ATF to say, well, something that is not yet a receiver but is readily converted into a receiver, a working receiver, that falls within the definition of firearm under the relevant statute, the 1968 Gun Control Act. I think there's a pretty powerful statutory argument that it doesn't, because in the statute, the 1968 Gun Control Act, they specifically say that something is a firearm even if it is not operable at the moment, but if it's readily converted into a firearm, then it is a firearm because it's readily convertible. They could have used that same language with respect to receiver. So a working receiver is considered to be a firearm under the 68 Gun Control Act, but they didn't add that additional language. There's nothing in the act that says, or in effect, a not operable receiver that could be readily converted into a receiver. And so the challengers really fixated on that difference and said, look, and so did the Fifth Circuit, and said, we assume that when Congress uses verbiage like that in a statute in one part of the act, but not in another, the omission was intentional. And they, both the Fifth Circuit and the challengers in this case, argue that therefore a not currently operational receiver that could be readily converted into an operational receiver is just outside the scope of the ATF's ability to characterize that as a firearm within the statutory meaning of the 1968 Gun Control Act. Therefore, this law is invalid. To tie it back to the couch thing, the point is essentially that, yes, Congress could have said that the frame of a couch unadorned with cushions is a couch within the meaning of this act, and you have to have a serial number on it. But if they didn't, does the couch agency get to say, well, we can write a regulation that says you have to put serial numbers on couch frames anyway, because if you put enough cushions on it, it becomes a couch. And that's about the limit of the analogies, I think, in this case. We could do omelets, we could do some of the other things, but I like couches for this illustration.
Great. Well, sticking to couches, Drew, what was your sense of the debate about whether or not the act, when it talks about frames or receivers, includes ghost guns? The Solicitor General said the ordinary meaning of a noun like frame or receiver includes objects that are nearly complete but are missing just a few holes that need to be drilled. And Chief Justice Roberts suggested that, drilling a hole to complete the ghost gun doesn't just convert it into a hobby. And at the same time, some of the justices were more sympathetic to the argument that ghost guns were not included in this frame or receiver definition. How did you see the justices breaking down on this question?
So I'm going to, first of all, agree with most of the media takes, I guess, and headlines after oral arguments ended, that it seemed like most of the 9 justices were agreeing with the Solicitor General and with ATF. And there were, Justice Alito was particularly combative, and Justices Thomas and Gorsuch were, I guess, a little harder to read. My read when I read the transcript was that Justice Gorsuch sort of backed down at the end of his questioning. I also want to say that the person who was arguing the case for the government, for ATF, Elizabeth Prelogar, is one of the most gifted appellate lawyers alive right now. I mean, maybe the most gifted, but at least probably in the top 10. And she was at her best in this particular argument, and I think that so the government couldn't have wished for a better advocate for on that particular day. Most people thought that she did a good job. I do want to respectfully disagree with the couch point. And because I do think that if I pick